Go. Marquette law professor Ed Fallone is one of three candidates for the state Supreme Court. The election will be, let me check it, April 7th, but because there are three candidates, the primary is February 18th. Professor Fallone, welcome back to WisconsinEye.
It's always a pleasure.
Thank you. What's at stake in this election for the court?
Well, there's a lot at stake. We know the important role our state Supreme Court plays in our constitutional system. We have a divided governor's office, state legislature. The Supreme Court should be our neutral arbiter between those political branches. I think if you look across the state, many voters feel that the court's not playing a proper role and not really acting for all of us in the state, but is instead putting its thumb on one side of the scale or the other. And this is really an opportunity, our only opportunity until 2023, to make a change and elect a different kind of justice. And so I'm running as a constitutional law professor, someone with experience trying to make the justice system work better for our working families. And this is our chance to get that perspective on the court.
You ran in 2013.
Yes.
As a constitutional law professor, you've been watching this court. How has it changed and evolved since last time you ran, sir?
Well, I think that's a good question. And in 2013, I did run for the court. I received over 360,000 votes. Unfortunately, came in second, so that wasn't good enough. But I had a lot of support. I think at that time, I was talking about the dysfunction on the court. I was talking about how the justices had started dividing themselves into political tribes and were not working together. I don't know that the voters of Wisconsin really saw that yet. But in the years since, as I've continued to watch the court, I've continued to watch it get more and more dysfunctional, even than it was in 2013. And many people approached me and said, Ed, please run again. And so I decided back in March, the first candidate to announce, this is our chance. This is our chance to get a different voice on the court and someone who can build consensus and be independent and get us back to the kind of court we used to have.
You use the term putting thumb on the scale. What groups, what organizations, what special interest groups have had their thumb on the scale the last few years?
Well, when I refer to that, I'm talking about, if you read the opinions of the court, we definitely have 5 justices who seem inclined to rule a certain way that seems almost as if they're not being open-minded on the cases. They have a predetermined result. On the other hand, we have 2 justices you could say the same thing about. What I'm concerned about is that a good judge sits on a case with an open mind and listens to both parties, doesn't have a predetermined result before the parties even open their mouth. A good judge follows precedent, and a good judge always knows that it's not necessary to reach out and decide constitutional issues in every case. You should hold back and exercise judicial restraint. And so what I'm worried about is that we have a court that has forgotten it represents all of us, and we have 2 different sides that seem intent on not speaking to each other and heading in their own direction.
What are some of the major cases coming that could reverse past precedent or set major precedents? You're not on the court. Maybe you can talk about some of those, sir?
Well, as a constitutional law professor and someone who's a close observer of the court, I mean, obviously I see trends. I like to say that I understand the big picture. And there are certain agendas that interest groups have. They want to remake areas of the law. There's nothing wrong with that, right? Some of the greatest advances in our nation's legal history have been groups like the NAACP trying to end school desegregation, or like Ruth Bader Ginsburg and the ACLU bringing a litigation strategy to challenge gender inequality. So there's nothing wrong with that. But I do think there are certain movements afoot. One is there are issues relating to the separation of powers and whether our state Supreme Court can even hold the legislature to follow its own rules or hold the legislature to follow the Constitution. I think that's a real important question that seems to be being raised by certain groups. I think we have real issues relating to voting rights and the drawing of legislative districts. With the new census coming out after 2020, it's inevitable that we're going to have some more litigation, and the U.S. Supreme Court has said these are issues that have to be resolved in state Supreme Courts, not in federal courts. And then we'll continue to have the same social issues arise, whether it's related to transgender rights or same-sex unions again, or any of the various social issues where different interest groups seem to want to test the boundaries.
The court upheld the lame duck laws.
Yeah.
Did the court get it wrong?
Well, I've criticized that decision, and I've criticized that decision
Because of a branch of powers, excuse me.
Yeah, separation of powers.
Separation of powers is what I was trying to say. Thank you.
And this is not the first time. We've seen in several decisions by a majority of the current Supreme Court in our state that they have a view that because the legislature is a separate branch from the courts should not tell the legislature that they have to follow their own procedures, whether it's the open meetings law, which was at issue in the Act 10 case,
yes,
or the definition of an extraordinary session, which was in the lame duck case, that the legislature decides for itself what the rules are, and the court can't tell them to follow the rules. I vehemently disagree with that approach. As a constitutional law professor, on day one of my class in constitutional law, we talk about Marbury versus Madison and the tradition of judicial review, and that our courts are the final word on what the Constitution means. And it's not for the legislature to decide. And so I think that in the lame duck case and in some other cases, our state Supreme Court majority was abdicating its responsibility. The rule of law is the rule of law. And I don't think it's ever appropriate for the courts to allow another branch of government to ignore the rule of law.
Having interviewed the other two candidates, there was one issue that I want to ask you about. Judge Karofsky, Dane County Judge Jill Karofsky, believes on the issue of criminal justice reform, justices should be able to advise the legislature and work with the legislature in criminal justice reform. Now, I just interviewed Justice Kelly. He said no, that if you want to make laws, run for the legislature. That's a function of the legislative branch. Where do you stand on criminal justice reform and whether the court should play a role in that?
Well, of course, a lot depends on how you're defining the phrase criminal justice reform.
The fact that we have the highest incarceration rate of African Americans, things like that.
Yeah. There's at least three things that our courts are currently doing that are relevant to mass incarceration and racial disparities in sentencing. And so I think it's just wrong for Justice Kelly to try and accuse anyone who supports these reforms of engaging in social activism. The courts are already doing it, and I'm talking about diversion programs where people with underlying mental health issues or addiction issues are identified before the criminal trial and are diverted to treatment to try and address the underlying issue. We have pilot programs in various counties around the state already doing that. We have an excellent Veterans Court pilot program in some counties but not others. I believe that we should make these diversion programs not the exception, county by county, but the rule. Now that's not social activism, that's simply the courts expanding their experimental programs now that they've proven effective statewide. We also have already our current Chief Justice, Patience Rogensack, engaged in a project having the courts collect statistics on racial disparity at charging and sentencing. The court's already doing that. I believe it should be expanded and it should be followed and that the statistics, once collected, should be analyzed to see what they tell us. And then we've got the computer criminal justice records, which are overseen by the courts. And there's a movement in the state legislature to create an expungement process where someone who has a criminal record could go to a judge and have it removed from the database so that landlords, so that employers wouldn't be able to see it, and it wouldn't be a bar for the rest of their life for them getting a house or an apartment or them getting a job.
What's your position on expungement?
I think that we definitely should support expungement. I think there's long been concerns about the potential misuse of the criminal record database, and it is under the control of the courts. And so if there is a potential for abuse, or if it is acting as a barrier to people who have served their complete sentence from integrating into society, if the courts control the database, the courts should be part of the solution. So I think Dan Kelly is completely off base when he tries to attack the courts. They are the administrator of our justice system. They already have their fingers in so many things.
Your campaign has issued 2 press releases stressing the importance of you would be the first Hispanic on the court. Why is this diversity important, sir?
we have a state Supreme Court that's all white. There are 23 states in the country that have all white Supreme Courts. The population of Wisconsin is a population that is growing increasingly diverse, and the fastest growing segment of our population are Latinos in the state. Depending on what county you go to in Wisconsin, the largest minority group may be Latino, African American, Asian or Hmong, or Native American. We have incredible diversity in our state. We need to have diversity on our court. And one reason is because in the justice system, when the only person of color in the courtroom is sitting at the defense table in handcuffs, that undermines the confidence that our minority communities have in the justice system. They want to see judges represented as well. They want to see prosecutors represented. We need diversity at all levels. And since we elect our judges, it can be difficult. When you have the majority being asked to vote, sometimes it's difficult to have the full diversity reflected. I think as a law professor who ran for the court in 2013, who has a reputation across the state, clearly qualified, having advised senators and given media interviews to national and international press on constitutional issues, I think this is a fantastic opportunity for us to elect the first Latino to our state Supreme Court.
Several years ago, the issue of do we elect or appoint justices emerged. Now, that hasn't been discussed recently.
Yeah.
But you're running for the court. You're in an election.
Yes,
Your
I am.
position, appoint versus elect?
I've thought about this a lot, and I have to tell you, I'm still a believer in electing our state Supreme Court justices. I am forced, as a candidate for the court, I am forced to go around the state and travel and meet the voters because I need their votes. And I get to go to Kewaunee County and ask, what are your local concerns? What are the issues here? I get to go to Wausau or Grant County and ask the same question. And when I sit on the state Supreme Court as a justice, I will be a better justice for having done that. The downside, of course, is electing our judges injects money into the process.
That's where I was going next. Go ahead.
It's very expensive to run a statewide campaign. The typical culprit is TV advertising expense, and that allows big money donors to have an outside influence. I think the way to address that, it won't be relevant in my campaign. I'm not trying to do anything. I'm not advocating a policy right now. I'm simply saying as a matter of good government looking forward, someone with experience now in 2 campaigns for the court.
Right.
I think in the future we should look at public financing of Supreme Court races to try and get this chasing after big donors under control. It's not good for our courts.
At the end of the year, let's stay on this subject. At the end of the year, you had raised the least in campaign cash. With what campaigns cost? How big of a disadvantage is this? And have you established guidelines of who you will and will not take money from?
I am accepting the assistance of anyone who wants to get our court back on track and wants to get us back to the independent court we used to have. Mm-hmm. So I have no restrictions on contributions. I'm always amused at how much the media, I'm not trying to criticize you, but how much the media focuses on the strategy and the game-playing aspect of elections.
That's not only true in Wisconsin, it's true nationally.
The reality is, it doesn't matter who raises the most money. What matters is, do you have enough money to have an effective strategy to win? And we have a very effective ground game planned for the campaign. I actually pay a lot of attention, as you might expect, to data on what is effective ways to reach and convince voters. And the most effective way to get people in the polls to vote for you is person-to-person contact. Knocking on the door, having a conversation, phone calls, having a conversation. The data shows that's the most effective way. So the fact that I'm not going to be as capable of running statewide television ads doesn't concern me as much, because that's not the most effective way to win votes. I think I have a strong ground game in place, and I think we're really going to do well February 18th.
Voters across the nation they may be distracted by the impeachment trial now going on in the U.S. Senate.
Yeah.
They're busy. They're with their lives and their kids and all that.
Yeah.
How can you get them to focus on a Supreme Court race with all these distractions?
I actually have found that the ongoing situation in Washington, D.C. has been helpful to my campaign.
That's
because
intriguing.
It has reminded voters of the value of expertise. When the members of Congress call 4 law professors, constitutional law professors,
Yes.
to testify, to explain our constitutional impeachment process.
And they split 3-1, excuse me.
It's okay. I know who they are, and I understand why they split. But the public understands, there's value to having a justice on our state Supreme Court who actually has spent a quarter century writing and teaching about our constitutions and who has spoken up about free speech, equal protection. None of these issues are new to me. And so I think we have a renewed understanding of the value of experience on our state Supreme Court. And I'll also say this. Chief Justice John Roberts gave a speech not too long ago where he said something interesting. He said, our judges have an obligation when they issue their rulings to explain our constitutional system to the public in their rulings, and not to write kind of abstract or obscure opinions, but to use their opinions to help educate the public. And I think he was exactly right. And I think one of our problems on our current state Supreme Court is I read their decisions. They seem incredibly self-indulgent to me. I see decisions where the justices are pursuing their own pet theories. They're not talking to each other, and they're forgetting they're supposed to be explaining the law and their reasoning to all of us. And so that is an opportunity, I think, for someone like myself on the court to really play a leading role, building consensus and getting the court back on track.
Justice Roberts also responded to a presidential tweet, said, we do not have Trump judges, we do not have Obama judges, we do not have Bush judges.
Yeah.
Here's where I'm going. Jill Karofsky is endorsed by the Democratic Party, and Justice Kelly is endorsed by the Republican Party. Mm-hmm. Where does that put you in this
I don't think
partisan debate for a nonpartisan job?
Well, absolutely. But I'll just correct you. I don't think either one has been endorsed by the party. They've certainly embraced.
That's a better term. Thank you for the correction.
They've embraced a political affiliation. I have not. I'm the candidate who has resisted any attempt to do that because I absolutely believe that we should have an independent judiciary without this partisan bickering. People are so tired of every walk of... You can't go to a Starbucks and order a latte without having a political fight break out. And people are sick and tired of it. And they understand that the one place we should not view all disputes through a partisan political lens and turn it into an us versus them is our state Supreme Court. And I'm the candidate who has absolutely refused to engage in any sort of political attacks because I know the voters don't want it. They want to get back to the kind of court we used to have. We used to have a state Supreme Court that was nationally respected. No one would have accused any of the justices of having a partisan agenda. The voters don't feel that's the case anymore, and they want to get us back. And the way to do that is to have candidates who refuse to run a partisan campaign.
The role of third-party groups in Supreme Court elections. Are you calling for no third parties to get involved for any of the 3 candidates, as naive as that might be? Because Justice Kelly told me they have a First Amendment right.
I think you just called me naive. Look, Justice Kelly...
If I did, I apologize.
No, I'm kidding.
I understand.
Justice Kelly says a lot of things that quite frankly, are convenient talking points, but they don't withstand logical scrutiny. It's very simple. No one can force a candidate to accept help from a special interest group or from a partisan group. And here I'm talking, let's put aside the money part. Let's talk about the fact that Justice Kelly asked the Republican Party to help him collect nomination signatures in his campaign. No one forced him to do that. He chose to do that. It was convenient for him to do that. He should not have done that, in my opinion. I hire my own staff. I don't accept anyone loaned to me from a political party for free. I rent my own facilities. I don't accept anyone offering me a free facility, right? I pay with my own money so that I can be independent. Maybe that's why I had number 3 on the fundraising list, because I'm paying my own way. Mm-hmm. I chose how to do that because I believe in an independent campaign. It's incumbent on the candidates. No one is forcing them to accept this sort of assistance. And I think until the candidates recognize that, we're going to have these problems. It's instructive to me that in the ongoing voter purge lawsuit, the Wisconsin Supreme Court did not take up an immediate appeal because Brian Hagedorn, Justice Hagedorn,
Former Court of Appeals judge.
former Court of Appeals, sided with the two more liberal justices.
Yes.
And immediately there were some on, I guess you would say, conservative media who went out on the airwaves and said, I guess Justice Hagedorn forgot which team he was on. The reason why people think that way is when justices and candidates behave in a way that sends that message. I refuse to behave that way.
Can you say, since you're not on the bench, how you would have ruled on just that case, whether the Supreme Court should get involved in the Court of Appeals versus Washington County on the voter movers case?
I'm very comfortable criticizing cases that are completed. This case is still alive. I don't want to either influence it or, if God forbid, it's still alive a year from now when I'm on the bench. But it's an interesting dispute. It really is. It's really a question of statutory interpretation. And all I can say is there's one section of the statute that seems to suggest the purge has to take place automatically. There's another section of the statute that seems to suggest the first section doesn't apply. And it's just a straightforward question of which section the court should enforce.
I was intrigued by a Journal Sentinel story that traced the positions of all three candidates on same-sex marriage, abortion, gun control, and Act 10. Are those relevant in this election?
Yes, and people still care about them. And I try to explain.
You want to walk through your positions quickly on those four?
On all of them quickly?
Yeah, a same-sex marriage.
Well, same-sex marriage, I think the United States Supreme Court case,
2015,
Obergefell,
yes,
should be understood as part of the tradition of the United States. We have a natural right to equal protection under the law, and that means at any time a group that's treated differently can file a lawsuit and force the government to justify their different treatment. And in our nation's history, we've seen, for example, in the Brown versus Board of Education and the desegregation cases, a kind of social segregation of races was challenged, and saying the reasons for it are no longer standing up to scrutiny. With Ruth Bader Ginsburg and equal protection, equal rights for women, same process, right? This idea that women belong in the home and not in the workplace is outmoded, and it no longer justifies treating women differently under the law. And I think Obergefell in the same-sex marriage case is part of that tradition of a group saying, you know, the justifications that have always been used for not providing legal marriage to same-sex couples no longer withstand scrutiny. So looked at in that view, I think it was an appropriate decision.
Roe versus Wade, settled law?
Absolutely settled law. The U.S. Supreme Court has been asked multiple times to overturn it and has not. And I believe it would be wrong to overturn settled precedent like that solely because you change the bodies on the court. And I think that's a horrible message to send.
The Heller case out of Washington and the Second Amendment also settled?
To a certain extent, yes. I think I've written on the Heller case, on the Second Amendment, right to bear arms. It's in the public record. I'm not running away from that. It was a case of activism on the right. I mean, Antonin Scalia took words out of context in the Second Amendment, rearranged them and scrambled them and created something new. So if you're against judicial activism on the left, you should also be against it on the right. If it's bad across the board, not just when the other side does it. But I have said consistently in this campaign, and it's been my position over my career, I don't believe you should overturn prior precedent just because you believe it was wrongly decided. It's important to respect precedent because, and this is where I also differ with Justice Kelly, my opponent, if every prior precedent is fair game for being overturned,
yes,
then every judicial election, every judicial appointment becomes all-out nuclear war because everything is up for grabs. And I believe that's the problem. We need to get politics out of the courtroom, and the way to do that is respect precedent. So I would not advocate overturning Heller. The right to own a handgun in your home for your personal protection has been established through, Justice Scalia's textualist parsing of the statute. Yes, it's established. I would move on.
What's your criteria for getting off a case, recusing?
I think you and I have been talking about this for 7 years.
Yes.
Well, I haven't changed. Absolutely. Everyone has a right to make campaign contributions to help elect whoever they want, but no one has a right to select the individual judge that's going to sit on their case. And if someone is a litigant in the courtroom and they leave the courtroom having lost their case, and they can't tell whether they lost on the merits or whether they lost because the opposing party had given campaign contributions to the judge who decided the case, that doubt and uncertainty is toxic to our system. And so it is absolutely necessary for the Supreme Court to change its rule and require justices to step down and not hear cases that involve major campaign contributors or groups that spent major amounts of money independently in support.
Define major, 5,000, 10,000, because you and I know that someone can now give up to 20,000.
Yes,
to a candidate. You could receive 20,000. You may or may not have. Excuse me, but
I think you just did a campaign ad for me.
I tried not to.
Well, as you know, we had a group of 50 retired judges who submitted a petition to the court, laid out a proposed rule that I found was eminently reasonable. That set for the state Supreme Court, it set the limit at $10,000. More than that requires recusal. Less than that, not. And within a couple years of the case being pending, so something that was contributed, in the past, not so important. I think that was a reasonable standard. I can tell you as a candidate now twice, there's very few individuals who donate more than $10,000 in a judicial campaign. So the universe of people who might be, in some sense, discouraged from making donations is so small. I really don't see that as a problem. It was a very sensible petition from the judges, well thought out, and the court did not adopt it. And I think on day one as a justice, I will continue to advocate for that reform.
Justice Kelly voted to close administrative conferences. Yeah. Should they be open?
Yes.
Why?
Yes. And I've written that too. This is an easy interview. You keep asking me positions I've taken over my career, so I just can be consistent. All three branches of government should be open and transparent. We have a tradition in Wisconsin, first of all, ingrained in our Constitution of open meetings in the state capitol. We also have an open meetings law statute that's very broad. We have a very strong tradition of transparency in Wisconsin government. And I think our state Supreme Court has failed to adequately protect and uphold that tradition. And in particular, I was in favor of the court opening its administrative hearings to the public because they are making the business of government, right, as they oversee the administration of the courts. They're not discussions about individual cases. They're discussions about, running the courthouse and security and petitions like this petition to change the rules and require recusal. Right. This is the business of government, and like any other government, it should be open to the public.
Your position on civil Gideon, someone accused in a civil action, important issues to them, eviction or child custody. Mm-hmm. Should they have a right to a court-appointed attorney?
Well, as you know, I've been working my entire career to increase access to justice for working families in our state. At Central Legal, a nonprofit, providing lawyers in divorce and tenant rights cases, misdemeanor cases, with the Catholic Charities Legal Services for Immigrants, providing lawyers in families and immigration proceedings. So this is an issue I've worked on for over a quarter century, really. I think there may be a point where civil Gideon is necessary. It is. We have, for example, in our rural counties, there's a crisis in finding lawyers. I mean, there's a crisis when families in bankruptcy issues or divorce issues in a rural county. Sometimes there's no lawyers, period, much less affordable lawyers. So we really need to have justices on our court who are focusing on making sure that the court system is accessible to everyone, and people without the money to hire a lawyer don't get shut out, or else they get on their own in the courts and they get a far lesser quality of justice. I think there are some ways that the court can try to address that before we get to civil Gideon. Okay. I certainly think, for example, there's avenues where the court could try to expand Skype or closed circuit lawyers appearing from a distant location, for example. I think there are many avenues that could be explored. I would not necessarily advocate one particular one, but what I would say is our court needs to take this seriously, and as a justice on the court, I will continue fighting to improve access to justice.
Final question, closing argument. Differences between you and Justice Kelly and Dane County Judge Karofsky?
Yeah. Well, I think it's a chance for change, really. We have had too many of our justices. We've sort of reflexively gone to the same universe of people, the same narrow experience for our state Supreme Court justices. And what I say as I go around the state is let's pause and let's ask what kind of voice and what kind of perspective is not currently represented. And I bring the constitutional law expertise. I would be the first Latino on the court. I've been helping our immigrant communities in the state for 25 years. I am someone who stood shoulder to shoulder with working families, trying to make the justice system work better for them so they get equal treatment to those who have more resources. Isn't there room on our court for someone with that perspective, that experience? And when I say that, people around the state agree with me.
Marquette Law Professor Ed Fallone is one of 3 candidates for a 10-year term on the Supreme Court. The primary is February 18th. The general election is April 7th. Ed, good to see you again.
Great to see you.
And a programming note, you can now see WisconsinEye's interview with all 3 candidates, wisconsineye.org. Thank you, sir.
My pleasure.
Thank you.
This program is a production of WisconsinEye, an independent, nonpartisan, nonprofit media network with a mission to inform, educate, and engage the citizens of Wisconsin. WisconsinEye is the nation's first and only independently funded state civics broadcast network, providing gavel-to-gavel access to government proceedings and events at the state capitol.